your patience. Do you want to introduce yourself?
We can do that afterwards.
I'm going to turn my phone on just to make sure. Everybody have their phone on? Okay, pre-trial.
Your Honor, my name is Sandy Ulatequera. This is my co-counsel, Gigi and Sarah White, and together we make up the plaintiff. Just so Your Honor is aware, today's case is a civil case, and the plaintiff, Andy and Lee Park, are bringing forth a suit of negligent parental supervision against the defense, Hayden Duran. On August 18, 2010, Hayden Duran's child, Jesse Duran, shot and killed the daughter of the Parks, Sydney Park. And we are asserting that Hayden Duran's parenting was the direct and proximate cause of the plaintiff's child's death.
Any pre-trial matters that
Yes, we also have some evidentiary matters to take care of. At this time, we'd like to enter in Sydney Parks' autopsy into evidence, as well as the statement made by the defendant's child, Hayden Duran, immediately after the
autopsy
shooting.
and statement?
Yes.
Any other evidentiary matters?
No, that's all, Your
Do you have
Honor.
any objections to either of those two?
No, sir, we don't.
Okay.
Should I copy the closing comment? With that, Your Honor, the plaintiff is ready for trial.
Okay, thank you. Defense?
Name and appearances, Your Honor.
Please.
My name is Logan Young, and along with my co-counsel of Kirk President
Good morning, Your Honor.
and Caitlin Wetz,
Good morning, Your Honor.
we represent the defendant Hayden Duran in today's case. Your Honor, this is a case about a firearm being discharged in the plaintiff, the Parks home, on August 18th, 2010. There were two children inside the home when this incident occurred, the plaintiff's daughter, Sydney Park, and the defense's daughter, Jesse Duran. The gun being discharged led to the death of the plaintiff's daughter, Sydney Park. May I approach the bench, Your Honor?
Sure. Do you have evidentiary matters?
No, sir, we do not.
Are these already admitted into evidence?
Yes, sir, these are not these special instructions. Figuring to the bench, a copy of the special instructions, the stipulations, the pretrial order, the Midland Civil Code, and the case law.
Thank you.
Your Honor, the defense would like to bring your attention to stipulation number 1. Stipulation number 1 states that damages are not an issue in today's case. We'd also like to bring your attention to pretrial order motion number 1. Motion 1 states that no post-incident photos of Sydney Park may be used by either party. Lastly, Your Honor, we'd like to bring your attention to case law Davis v. Happyland. It's at the back page. Davis v. Happyland states that the deceased party and the person prosecuting on behalf of the deceased are both considered parties for evidentiary purposes. Your Honor, with that out of the way, we ask for a few housekeeping matters. May we invoke Rule 615 constructively, sequestering all non-party witnesses?
Yes, that's fine.
May we assume all exhibits pre-marked?
Well, all of your own exhibits will be A through Z. Yours would be 1 through 100. Okay, that's fine.
May we assume all witnesses pre-sworn?
Yes.
May we assume objections are outside of the jury's ear?
Yes.
And lastly, Your Honor, since this is our first time in your courtroom, may we move about the well freely during openings, closings, and examinations?
Yes.
With that, Your Honor, the defense is ready for opening statements.
And you can sit down. You can forego the just, if you want to approach the witness, then ask, but you don't have to initially approach or ask to approach the opposing counsel.
Thank you.
All right. Yes. Opening statement.
Yes, Your Honor. May it please the court. Today's case is a story of two parents who took every step and one parent who ignored all of the signs. And the result of that is that on August 18th, 2010, the defendant's daughter, Jesse Duran, shot and killed the plaintiff's daughter, Sydney Park, when both children were only 11. But this could have been predicted and prevented. It could have been predicted and prevented by Hayden Duran, the defendant. Now let's look at all of the signs that Hayden Durant ignored. It's years before the shooting, and Jesse, Hayden's child, is just a small kid. And he has a fascination with firearms and the Army. And he asks Hayden for war-related video games. And though they're rated for children far above Jesse's age, Hayden buys them for her. And now, it's a few years later, Jesse is just turning 10. And Jesse wants to play first-person shooter games, where she can play from the perspective of the shooter. And because she's 10, Hayden now buys these for her as well. Now it's a few months before the shooting, and Jessie Durant is asked to draw a picture at school, and she brings it home and shows it to her father. And it's a picture of her chasing the bad kids away with guns, where Jessie writes, "I love my gun." Now, it's a few months later, and you will hear that Jessie is having some trouble at school. And 4 months before the shooting, Hayden Durant receives a disciplinary notice from that school because Jessie has gotten into her third fight of the year. And this one is so severe that she is suspended for a full week. Now, a month later, Hayden Durant writes an email to his friend saying that he caught Jessie and her friend Sydney playing a version of the game where instead of shooting the bad guys in the video game, they're taking turns shooting at each other's characters. And you will hear that Hayden Durant writes to his friend that he is concerned about Jessie. But he ignores these signs as well, and he does nothing. Now, it's the day before the shooting, and Hayden Durant learns that his child, Jessie, has found out that there is a gun in the Parks home, and that Jessie wants to play with that gun. And now it's the morning of the shooting, and Hayden Durant takes Jessie over to the Park home to drop her off like he's done so many times before, except this time Andy Park tells Hayden that no one's going to be home because the regular babysitter can't make it. The children are about to be left home alone, while Hayden knows that Jessie wants to play with the Park's gun. But Hayden decides that instead of talking to Andy about it, he decides to go to work. And he leaves the children there. And while the children are there, they take the gun out. They play with it. They're careless with it. And then Jessie Durant points it at Sydney Parks' face and shoots her. Now, the next time Hayden Durant speaks to his daughter, it is for 7 minutes over the phone while Sydney is bleeding on the ground because Jessie just shot her. And during these 7 minutes, or after, neither Hayden nor Jessie call the police. The next time Andy Parks sees her daughter, it is just her tiny 68-pound frame under a white sheet with sparkly pink flip-flops poking out. The plaintiff has a burden today, Your Honor. We must prove to you, by a preponderance of the evidence, that, more likely than not, Hayden Durant had a duty to exercise reasonable care with his child. And we must prove that Hayden Durant did not fulfill that duty. And we will, Your Honor, because you will hear that Hayden Durant never disciplined Jessie.
Stop. It's time.
May I proceed with opening statements?
The safety wasn't on. For every single decision, the parks made, the safety simply wasn't on. My name is Caitlin Wetz, and along with my co-counsels Kirk Presley and Logan Young, we represent the defendant, Hayden Duran, in today's case. Now, the safety wasn't on at the park's home. As much as the plaintiff would like you to believe it was Hayden Duran who made careless mistakes that led to their daughter's death, it was the plaintiff's own failure to maintain a safe home, which is the reason why we're here today. Now, today you will learn that in May of 2010, the parks bought a gun, a Baker revolver. Over the next few months, their daughter Sydney learned the obvious location where this gun was stored and how to access it. Safety was left off for several key reasons. First, you will learn today that in May of 2010, the parks bought this gun and failed to properly store it within their home. The parks were marksmen themselves who grew up owning guns. Nevertheless, expert Ash DeRosa will come before you today and tell you that despite their knowledge, they left their gun in an unsafe location, an unlocked bedroom in the park's home, accessible to anyone. The safety wasn't on when the parks stored that gun. Secondly, you will hear today that the parks left the combination to that safe in an unlocked file drawer in the park's home office, a room where their daughter Sydney spent most of her time, often unsupervised. Moreover, the combination was simply a numerical list of the park's family birthdays, information that was readily accessible to Sydney. Safety wasn't on when the parks chose and stored that combination. Finally, you will hear today that on the morning of August 18th, 2010, Andy Park left Sydney and Jesse completely unattended. Witness Terry Chapin will take the stand today and tell you that on that morning, the parks phoned the neighbor across the street who said he would check in every few hours or so. The safety wasn't on when the parks made that decision. Now, throughout today's trial, you will hear several pieces of evidence that show that Hayden Duran took several precautions when raising his daughter Jessie. Jessie Duran herself will take the stand today and tell you that her father reiterated warning after warning that guns were not toys, but were rather dangerous weapons. Now, the burden of proof in today's case lies solely on the shoulders of the plaintiff. That means that they must prove to you by a preponderance of the evidence that Hayden Duran failed to exercise reasonable control over his daughter Jessie, that Jessie committed an act of recklessness, and that the parks suffered harm based on that recklessness. Now, they will not be able to meet that burden, ladies and gentlemen, because nobody is going to take that stand today and fault Hayden Duran for leaving his daughter in the park's care on that morning. Nobody is going to take that stand today and tell you that the parks have had a similar conversation with Sydney about the inappropriateness of firearms. And nobody is going to take that stand today and tell you that Jessie Duran had ever had any kind of consequence with a real firearm. Now, the affirmative defense in today's case is on the defense's side. That means that we must prove to you by a preponderance of the evidence that the harm suffered by the plaintiff is more attributable to wrongful conduct by the parks than by wrongful conduct of the Durans. If at the end of today's trial, if you feel that the parks, however tragic, contributed to their own daughter's death even 1% more than Hayden Duran, you cannot find him liable. Listen closely to the evidence heard here today. At the end of today's trial, I am confident that you will see the parks left the safety off.
call your first witness?
Yes, Your Honor. The plaintiff calls their first witness, Jules Sebastian. Hello, Mr. Sebastian. Can you introduce yourself today?
Sure. I'm Jules Sebastian, the lead forensic investigator for Breckenridge County.
And why are you here to testify?
On August 18th, 2010, Sydney Park, the daughter of the plaintiff, died of a gunshot wound to the head. I investigated the crime scene, and the ultimate purpose of my investigation was to determine who fired the gun that killed Sydney Park.
As the head investigator, why were you called to this particular case?
I investigate all high-profile cases in the county. Because I'm the lead forensic investigator, I have the most expertise to deal with complicated matters like this.
What expertise do you particularly have?
I've investigated over 200 crime scenes, I've supervised over 50 of them, and I've testified at over 30 trials where someone's freedom is on the line.
Are you being compensated in any way to be here today?
I'm a public employee and I was subpoenaed to be here to testify.
I'd like to move to your investigation on the day of the 18th. How did that morning start out for you?
I was called to the Parks home, the scene of the crime, on the morning of August 18th. I entered the house from the west entrance, through the kitchen, and at the dining table I observed a young girl sitting with two officers. That girl was Jessie Duran, the daughter of the defendant. I then turned right into the living room, and I observed a young female lying on the floor between the couch and the coffee table. That young female was the victim of the case, the daughter of the plaintiff, Sydney Park.
After identifying these individuals, what steps did you take?
I collected forensic evidence at the scene. I swabbed for gunshot residue, I lifted for fingerprints, I observed and documented any blood at the crime scene.
What did you do with this evidence after you collected it?
I took it back to the lab and ran 3 specific methods or tests on this evidence. I specifically conducted a fingerprint test analysis, gunshot residue analysis, and a blood spatter analysis to this evidence.
Are these tests generally relied upon in your field?
Yes, absolutely.
I'd actually like to discuss now your conclusions specifically. First, before doing so, did you rely upon these methods and did you apply them properly when coming to your conclusions?
Yes, I did.
Now, if possible, is it possible to take these conclusions chronologically?
Yeah, that's often helpful in a trial like this.
Can you explain to me, or can you tell me what the test indicated occurred with the events leading up to the shooting?
The fingerprint testing indicated that both Sydney and Jessie had touched the gun at the crime scene. But more specifically, I found partial prints on the shell casing of the bullet that matched Jessie Duran. This was the bullet that was loaded into the revolver at the crime scene.
And you said that you found partial prints on the shell casing. Can you explain to me why you would see partial prints?
Well, actually, that's to be expected with an object like a bullet casing. Oftentimes, my students at the academy ask me about this. Do you have a pen so I can demonstrate this? That's often helpful.
Permission, Your Honor, to get Mr. Sebastian a pen? Mr. Sebastian, can you step down and show us what you mean with the pen?
Sure. I'm going to use the pen cap here. You'll note that it's cylindrical, just like the shell casing of a bullet. You'll also note that only part of my finger is touching this shell casing, and because only part of my finger is touching it, you're only going to get a partial print. That doesn't preclude me from declaring this a match to anybody, but I'd have to go through additional methods of authentication of their standards to make that determination.
You can take your seat now, Mr. Sebastian. Now, you're speaking a little bit about a match and a fingerprint analysis. Can you tell us what you consider a match?
Yes. 16 points of similarity is a preference to declare 2 prints a match, but it is not required to do so.
After establishing through fingerprint analysis that Jessie had been holding the gun, can you tell us if there's any evidence indicating what he was doing with it?
Yes, the gunshot residue indicated there were high concentrations of gunshot residue on Jessie's right arm, and far lesser concentrations on the left half of the body. That indicates that Jessie had her right arm extended just like this when the firearm went off.
If Jessie was holding the gun like that, what was Sydney doing?
The blood spatter analysis indicates that Sydney Park wasn't even facing Jessie Duran when the gun went off. Actually, Sydney Park was facing the other direction, and she was slightly turning her head towards Jessie when the bullet struck her.
Can you tell the court anything about the distance between Jessie and Sydney?
The tests indicate that Jessie Duran was approximately 6 feet away from Sydney Park when the gun went off.
After conducting all of these tests, can you tell us the cause of death for Sydney Park?
Sydney Park died of massive trauma as a result of a gunshot wound to the head.
And Mr. Sebastian, who fired that deadly gunshot?
Jessie Duran.
Pass the witness.
Permission to cross the witness, Your Honor.
Please.
Good morning, Dr. Sebastian.
Good morning.
Mr. Sebastian. Now, Mr. Sebastian, you were called to the home around 10:05, is that correct?
That's the time that a call was placed to my office, yes.
And you arrived at the scene about half an hour after the incident, correct?
That's correct.
And when you arrived at the scene, Terry Chapin was in the home.
Terry Chapin was in the home when I arrived, but soon exited afterwards.
So Terry Chapin was in the home when you arrived.
That's correct.
And so was Andy Park.
That's correct.
And so were 2 EMTs.
That's correct.
And several officers.
Some officers were in the park zone, but that was to secure the crime scene.
And Officer Williams.
Officer Williams was the supervising officer, so naturally he'd be at the scene.
And Jesse Duran.
Jessie Duran was at the home as well.
So that's 9 people that were at the scene before the forensic evidence unit was ever there.
That's correct.
Okay. Now, Dr. Sebastian, or Mr. Sebastian, Andy was allowed to remain in the living room, wasn't she?
Andy Park was allowed into the living room, but was immediately removed afterwards to prevent contamination at the scene.
Andy was attempting to touch Sydney's body, correct?
Actually, we don't actually know that, but he was reaching towards the body and was quickly prevented from doing so.
You retrieved a revolver from the ground, yes?
That's correct.
And you took fingerprint swabs of this revolver.
That's correct.
And both Sydney and Jesse's fingerprints were on this revolver?
That's correct.
Sydney's fingerprints were more prevalent than Jesse's fingerprints on this revolver.
They were approximately equal.
Okay. And you tested gunshot residue from both Sydney and Jesse.
That's correct. I swabbed both individuals for concentrations of gunshot residue.
And from your results, you found that Jesse probably shot with his right hand, with her right hand?
Yes, the gunshot residue testing indicated that Jessie Duran had her right arm extended like this when the fire went off.
Okay. And that was based off of the gunshot residue concentration on the right hand or on the clothing, or?
Both.
Okay. And you took samples from both Sydney and Jesse?
That's correct.
Okay. And you swabbed the safe for fingerprints as well?
That's correct.
And you found Sydney Park's fingerprints on the safe?
Yes. I found Sydney Parks and Jessie Duran's fingerprints on the scene.
Okay? Now, Dr. Sebastian, Mr. Sebastian, the wound analysis shows that it's likely that Sydney and Jesse were sitting down,
That's correct.
and it also is likely that Sydney and Jesse were facing each other whenever the bullet hit Sydney.
That's not correct.
What happened then?
The blood spatter analysis indicates that Sydney Park was not facing Jessie Duran when the bullet struck her. She was facing the other direction and was slightly turning her head towards Jessie when the gun went off.
Thank you. No further questions.
No further questions for this witness, Your Honor. We ask that he be allowed to step down.
Second.
You want to call your second witness?
Yes, Your Honor. If you're ready, we call our second witness, Dr. Campbell Solo, to the stand. Good morning, Dr. Solo. Would
morning.
you please introduce yourself?
Sure. Good morning, everyone. My name is Campbell Solo. I'm a practicing forensic psychologist here in Midlands.
Do you know why you're here today?
I do, yes. I was retained by the family of the plaintiff to evaluate whether or not Jessie Duran was showing risk factors that increased the likelihood of violent behavior on or before the day in question, August 18th, 2010.
Well, before we go into the findings that you were able to come to, I'd like the jury to know a little bit more about you.
All right?
Would you just begin by telling us where you went to school?
Sure. I received scholarship to come to the States to continue my higher education, so I went to the University of Oregon to receive my bachelor's in psychology. I then received my medical doctorate from the University of Michigan, and that's when I began my residency at St. Mary's Hospital in Wisconsin. That's when I really developed my specialty.
You mentioned your specialty. What is your specialty in particular?
Over the years, I've kind of developed a specialty in adolescent forensic psychology. That means I evaluate psychology from a forensic perspective with children from the ages of 5 to 17.
Let's talk a little bit more about that forensic perspective that you
Right.
mentioned. What is that? What do you mean when you say you're a forensic psychologist?
Forensic psychology is actually the bridge between just general psychology and the criminal justice system. It requires learning fundamental legal principles and communicating regularly with attorneys, judges, juries like yourselves, and reformulating my psychological findings into the language of the courtroom.
So when you're beginning an investigation, what's your first step? Do you have people coming in to see you for an evaluation that you conduct, or?
No, it doesn't quite work like that. There's no big comfy leather couch that you come sit on and talk to me. It's much more after the fact. So what I look for are witness statements, typical things that involve the criminal justice system, affidavits and the like, to help me paint a picture of what happened.
How about for this case? What sorts of information did you gather?
I gathered the affidavits of the parties in this case. So that would be Hailey Duran, the parent of Jessie Duran, and also Andy Park, the parent of the victim in this case, Sydney Park.
Were you able to conduct an interview with Jessie Duran, the defendant's child?
No, I was not.
Did that in any way impact the reliability of your findings?
No. Interviewing the subject is always preferable. However, forensic psychology actually operates under the assumption that we're not going to be able to actually talk to the person in question. Because most forensic psychology is in the criminal sphere of the legal world, them talking to us might expose them to criminal liability, so we often don't have the opportunity to. So the science, you could say, has figured out a way to come to conclusions without actually having to talk to them.
Dr. Sullivan, on the whole, would you say that your conclusions, you had enough facts and data to come to them?
Absolutely, yes.
I want to talk about now what you do once you've collected all this information.
All right.
What do you do with it to actually evaluate?
The first step is a recreation of what happened from the moment that the violent incident occurred up until years before, if any violent instances were present in the child and around the parent. From that point, I apply psychological evaluation technique to the facts and then reformulate that, like I mentioned, into the language of the courtroom to see if the child in question exposed risk for violent behavior and what action the parent in this case did or did not make.
Is that the reliable method within your field?
Yes, adolescent psychology relies on both what the child was doing as well as the parent.
And did you reliably apply that method to the facts and data in this particular case?
Yes, I did.
All right, I want to move on and talk about what you were actually able to determine.
All right?
Could you just begin by telling us what your conclusions were?
Sure. My first conclusion was that Jesse Duran was at severe risk for violent behavior long before August 18th.
Objection, Your Honor, character.
Your Honor, my response would be that while we do intend with this witness to talk about instances in which Jesse Duran exhibited behavior that should have given Hayden Duran warning about what was to come, this is not to form a propensity argument. What we are doing is we are trying to show that Hayden Duran had knowledge of what his son was capable of, and that knowledge gave him an opportunity to predict and to prevent what happened on August 18th.
Your objection was to character evidence?
Yes, Your Honor. Rule 404 says that character traits may not be brought forth to prove actions fully therewith.
Do you want to reformulate your response on that?
Yes, Your Honor. We're not trying to show conformity therewith. What we are trying to show is that Hayden Duran had knowledge of these character traits and that he had an opportunity to prevent and predict what happened on August 18th. It's not a propensity argument. And we'd be fine with the jury instruction saying that the jury is not to take this as a propensity argument, but that it goes directly to Hayden Duran's knowledge.
Okay, so if the line of questioning continues to be with regard to Hayden's knowledge, then I'll allow it.
Absolutely.
So overruled.
Your Honor.
All right, Dr. Sullivan, you were just telling us what it is that you were able to find.
So the first step was Jesse was at severe risk for violent behavior on and before August 18th of 2010.
And you said the first step, was there another element?
Yes, the second and most important element is determining whether or not the parent, Hayden Duran, responded correctly to that violent behavior.
All right, well, I know when you were explaining your conclusion to me, you had a chart that you kind of put up in my office.
Yes.
Do you think that bringing that out today and letting the jury look at it would help you to explain your conclusions?
Absolutely, that's why I made it.
Your Honor, permission to just set up the courtroom to make use of a demonstrative aid?
Any objections?
As long as I'm able to reposition myself, Your Honor, to see if
That'll be fine.
And may Dr. Solo go ahead and step down into the well and use it?
Excuse me, Your Honor, at this time I would raise an objection to this demonstrative. This contains a chart that has information already filled out upon it. This is not a demonstrative, this is effectively leading the witness to conclusions.
Is this your chart?
Yes, I made it.
You can comment on his own chart, and just as long as it's positioned so that the defendant can see.
Of course. Will that be all right?
Yeah, that's fine.
All right. Dr. Solo, would you go ahead and step down?
Sure.
All right, Dr. Solo, would you just walk us through the steps and pieces to this chart?
Sure. This chart is essentially divided into three categories. The first is the child, in which I identified and highlighted certain psychological risk factors. The second column is what reasonable parents respond to whenever you are exposed to that violent behavior. And the third column is the application in this case. What responses Hayden Duran made into Jesse's violent behavior.
All right, well, let's take them column at a time. Would you just walk us through exactly what you noticed that Jesse Duran experienced that made him a risk?
Sure. I identified 4 specific categories that exposed Jesse Duran to violent behavior. The first being exposure to violent media.
How was she exposed to violent media?
The exposure was actually surrounded by the presence of violent video games intended for adults. These games involved first-person shooting scenarios in which a person through the eyes of the player would kill other people.
Did Hayden Duran know that his daughter was playing these violent video games?
Not only knew, madam, but participated with. The parent was playing with the child in this violent media that should never have occurred.
All right, let's talk about that second thing you have listed there. Fascination with firearms. Would you tell us what that is, what it means?
Yes, fascination with firearms is especially concerning in forensic psychology because of the child's age. Because adolescents are especially impressionable, the external stimuli affect them much more strongly than they might affect you or me. That impact is especially concerning. I uncovered evidence that Jesse Duran had significant fascination and even exposure to firearms.
Well, let's take those one at a time. You said a fascination and an exposure. How did you know that he was fascinated with firearms?
I knew that she was fascinated with firearms by some pictorial evidence. She would frequently draw herself with guns, using them on other people and expressing her even love for guns. And then I knew that she was actually exposed to guns even the day before the shooting. I uncovered that she knew about the Parks gun and even had a conversation with Hayden Duran about it.
What did this conversation between Jesse Duran and Hayden Duran about the gun consist of?
It consisted of some warning on behalf of Hayden Duran, so I do commend him for that. However, there was unusual amount of interest in that gun on behalf of Jesse, which was concerning from an adolescent perspective.
All right, let's go ahead and move on to the next points that you have there. Intense anger?
Yes.
What does that mean?
Intense anger is actually intertwined with instances of violence just generally, but what intense anger means is a very sporadic and intense moment of anger that contributes to overall violent behavior. I found significant evidence of this.
And did Hayden Duran know that Jesse was experiencing these moments of intense anger?
Absolutely. The school actually documented Jesse Duran's multiple fights among other students.
Objection, Your Honor, facts not evidence. The witness is now referring to a specific piece of evidence, a document that has not been brought to the course, has been not admitted in evidence.
Your response?
Under Rule 703, this expert is allowed to go into otherwise inadmissible facts or data in order to explain these conclusions. That's exactly what he's doing here today.
Conclusions may be explained, however, the expert witnesses are specifically barred from being conduits to hearsay. They do not simply allow otherwise admissible documents to pass through under the pretense of being basis for conclusions.
I have a question. Is the document that the doctor is referencing in evidence, is the document?
No.
Anyway.
If he's drawing, what was your response?
Was that by testifying from specific statements in the document, conscious document is a conduit to hearsay. He's not drawing his conclusions based on, he's testifying directly from the documents.
So hearsay, I understand, is okay from an expert witness. But the question is it okay to possibly fabricate a document that's not in evidence?
Your Honor, we don't need to enter this document into evidence in order to have him give his expert conclusion about it. He was able to look at all of these facts and data and come to a conclusion. And the reason that we're talking about this is to help the jury evaluate the conclusions that he came to. So we don't need to enter it into evidence at this time. However, I would respond to opposing counsel's statement that he's becoming a conduit to hearsay, and at this time, I don't believe that he has crossed that line. He's merely talking about an instance of violent behavior that Jesse Duran experienced, and it's especially probative because Hayden Duran received a letter from the school saying that his child was...
So I'll sustain the objection to the extent that the expert is referring to a document not in evidence. However, I'll overrule the objection to the extent that the expert is referring to his opinion on evidence that is in evidence.
Yes, sir.
Yeah.
All right, Dr. Silva, I'd like to ask you a little bit more generally about that intense anger.
All right.
Did Hayden Durand know that his daughter was experiencing these episodes of intense anger?
Yes. Based on my analysis, Hayden Durand was well aware of Jesse Durand's engaging in violent behavior, physical violent behavior, long before August 18th.
And what about that last one, loss of temper?
Loss of temper is interrelated with intense anger, but the loss of temper indicates the degree to which that intense anger occurs. When there's a loss of temper, that's one of the most concerning elements of psychological disorder.
All right, now let's move on to the second column there, the reasonable parent.
All right.
In response to each of these different warning signs and risk factors, what would a reasonable parent do?
For exposure to violent media, the correct response is to limit or eliminate that exposure. In response to fascination with firearms, a parent ought to remove the firearm, or even its presence, whether it's through a video game or through toys, or at least warn others about the child's fascination. The third and fourth together are related with just general discipline of the child, but most importantly, if the intense anger is severe enough, get medical help.
And what did Hayden Durand do in response to these warning signs?
In response to the first element, exposure to violent media, I concluded that Hayden Durand did nothing to eliminate or at least limit the exposure. Second, I also concluded that Hayden Durand did nothing to remove or even warn others about the exposure and fascination with firearms. Third and fourth, I do believe that Hayden Durand made reasonable efforts to warn the child. However, those efforts were not sufficient from a psychological perspective.
Why were they not sufficient from a psychological perspective?
Hayden Durand never got medical help for the child that showed extensive interest in violence and guns. Secondly, the discipline that he did provide was not sufficient.
Just in your opinion, this witness is clearly an expert today in issues of forensic psychology. However, this is no expert in the proper level of parental supervision that a child might require. The idea that a certain amount of parental supervision is not enough is ultimately an issue in the case for the jury to decide today, not for this witness to testify about.
So what's the official objection?
Opinion, Your Honor, that this is outside of the scope of the expertise of this witness.
Do you want to respond to that?
Your Honor, if they are objecting to an improper expert opinion under Rule 702, I would say that that is certainly not the case. We've laid the expert foundation that he is able to talk about all of the things that we're going into right now.
I agree, overruled.
Dr. Silva, would you go ahead and repeat your last answer? Why, from the perspective of a forensic psychologist, was Hayden Durand's action not sufficient?
While I will commend Hayden Durand for the at least attempt to discipline the child, from that psychological perspective, the discipline was plainly insufficient. And more importantly, never once got medical help for the child that showed risk of severe violence.
All right, Dr. Silva, could you go ahead and take your seat real
Sure.
quickly? I just have a couple more questions for you. We went through that whole chart and we were talking about what Hayden Durand knew and what he didn't know. And you seem pretty, you talked a lot about the fact that you thought Hayden Durand knew about most of these things. What if Hayden Durand wasn't aware of it? What would you say to that?
In the field of adolescent forensic psychology, not knowing is no excuse. Parents are responsible for monitoring their children, both legally and commonsensically. They're responsible for their children's upbringing and whether or not they engage in unacceptable behavior. They're responsible for responding to psychological disorders.
In your professional opinion, should Hayden Durand have had any ability to predict that something like what happened on August 18th was possible?
Absolutely. Those four elements are warning signs for a reason. They're easily recognizable by parents who have no psychological training. He could have predicted easily with what Jesse Durand was showing.
Well, if he was seeing all of these things, and if he wasn't taking the steps that you say were necessary, did he at least make an effort to warn the people around him of what was going on so they could take precautions?
Sadly, no. At no point did Hayden Duran even warn others about Jesse Duran's violent behavior, and that I believe to be inexcusable. Had he at least warned the Parks of Jesse's violent behavior, Sydney might still be with us.
No further questions at this time, Your Honor.
Hey, Chief. Good morning, Dr. Solo.
Morning, sir.
Dr. Solo, you were hired in order to ascertain a propensity that Jesse Duran may or may not have had for violent behavior, August 18, 2010.
Correct.
And so, starting that analysis, you looked for the classic warning signs, risk factors for violent behavior.
Psychological evaluation, that's right.
Right. And there are 12 common risk factors for violent behavior, correct?
I'd agree that there are 12 hallmarks, however, the science out there indicates that there are multiple, even in the 50s and 60s science, but in this specific case I looked for 12.
And yet you only found 4, correct, Doctor?
4 significant risk factors, yes.
So, among these risk factors are genetic or hereditary conditions, right?
You're absolutely right.
And you found no evidence of this risk factor with Jesse Duran.
No, I do not.
Next was sexual abuse at a young or early age,
That's right.
and no evidence of this was found with Jesse Duran.
Correct.
You looked for stressful home life or neglect in the home,
That's right.
and no evidence was this. No evidence was this was found with Jesse Duran.
No, that psychological risk factor was not present in my evaluation.
Looked for poverty. Poverty, Jesse Duran.
No, I do not find that Jesse was at risk for poverty.
Right. And you looked for drug use by the parent,
That's
which
right.
also did not find.
No, I did not find that Hayden Duran was using drugs.
And you looked for the presence of firearms in the home.
That's right.
And the Durans did not own a firearm.
They did not own a firearm, however, I do believe elements of the risk presence of firearms were present.
However, the Parks did own a gun, correct?
You're right, sir.
And you don't believe in owning guns in the home, do you, Dr. Solo?
No, personally, I don't believe it. I'm just not a fan of guns, I'd say.
You believe the only way to keep children safe from guns is the best way, at least, is to remove them from the home entirely.
I'd say that's preferable, but I understand that it is all right to own one, so I respond accordingly.
And failing that removal, the best way to keep children safe is to keep guns properly and safely stored, correct?
I'd agree to that, sure.
And ultimately, you believe it is the parents who own and introduce this gun that are most responsible for keeping children safe around it.
Absolutely.
Thank you, Dr. Solo. Nothing further, Your Honor.
No, no. Can this witness step down?
Yes, sure.
Thank you.
For your second, please.
Yes, Your Honor. Plaintiff calls Mrs. Angie Park. Good morning, Mrs. Park. Can you introduce yourself?
Sure. My name is Andy Park. Sydney was my little girl.
Can you tell us a little bit about your family, Mrs. Park?
Yeah, I went to the Navy right after high school, so I started college late. But when I was there, I met Lee, and that's like I found just the person I wanted to be with forever. We eventually decided to have kids, but it took us a while. And when we found out we were having Sydney, it was the best day of my life. She was the happiest little girl.
Mrs. Park, I'd like to show you something. Show you opposing counsel. Mrs. Park, can you identify this?
This is a picture I took of Sydney right after her 11th birthday.
Is this a fair and accurate depiction of Sydney?
Yeah.
Your Honor, at this time I'd like to enter plaintiff's exhibit 3 into evidence.
Objection?
Objection, Your Honor, relevance. As my co-counsel pointed out in pre-trial, this trial is not about damages, and I believe that opposing counsel will try to use this picture to invoke some kind of emotional response that will relate to those damages.
Why is this picture more probative in value than its prejudice?
Well, Your Honor, this picture isn't intended to show damages to the Park home. Certainly, the fact that the Parks lost their daughter isn't irrelevant in this case.
May I respond, Your Honor?
Sure.
I don't believe that this picture goes to show any probative value. However, it does unfairly prejudice the jury.
What's the value of the picture again to the facts?
Your Honor, there is no rule against, or I believe harm in humanizing this victim. I mean, it is a person who died, and the probative value of showing that is conveying that it is a person who died. That's not unfairly prejudicial, Your Honor. It's not a picture of her after being shot that's going to prejudice the jury in terms of showing any very graphic, violent images. It's simply a picture of the little girl before she died.
I think it's a valid objection, I'll sustain it.
Can I get that back from you, Mrs. Park? Mrs. Park, can you tell me a little bit about Sydney?
Sure. Sydney was a lot like me. I started reading to her when she was really young. I always loved the greats like Tolkien. And when she got older, she started reading them back to me. And I'll never forget her starting The Hobbit, talking about the Hobbit hole. It was a great thing to do.
Mrs. Park, how old was Sydney?
She was 11. She would have been going into middle school. She made it to September that year.
Mrs. Park, I'd like to talk about the gun that you had in your home. Can you tell us a little bit about that?
Yes. My husband and I, we had our home broken into in January of 2010. So we wanted to buy a gun to feel safe. I was in the Navy. I was a certified marksman. Lee, he had been hunting ever since he was a kid. We knew how to act around guns, so we bought one.
Did Sydney know how to use a gun?
No, Sydney was only 11. She didn't even know we had a gun until that summer.
So since Sydney wasn't supposed to use the gun, did you take measures to make sure she wouldn't?
Oh yes, ma'am. When we got the gun, I did research to determine what would be a good safe to keep it in. I bought a Gigi safe, one of the best on the market. It was a combination safe. Put the gun in it in our bedroom, always unloaded. We kept the bullets in the garage. I thought we were doing everything right.
Okay, now, Mrs. Park, I'd like to talk about Jessie Duran. Can you tell us who Jessie Duran is?
Jessie was Sydney's best friend. I met Hayden back when they were just like 3. We worked in the same hospital, and when they were 5, he told me that the house next to theirs was for sale. So we moved into Fairview, and for the next 5 years, the kids were inseparable.
Now, Mrs. Park, did you know that Jessie had violent behavior?
No. Jessie acted fine at our house when I was around. I never knew she had any trouble at school. I didn't know she was getting into fights. I thought Hayden would have talked to me about something like that. We were close.
Okay, Mrs. Park, did you have any reservations about Jessie?
Not until she turned 10. That's when she started playing video games that I wasn't okay with. In 2010, I actually had to take one away from her that she brought over to my house. But that was it. I thought she was a normal kid.
Okay, Mrs. Park, I know this is difficult, but I need to ask you about the day of August 18th, 2010. Can you tell me how that morning started out for you?
Normal. We woke up. I got Sydney ready for the day. I made her breakfast. My husband was out of town on business, so it was just us. The babysitter called and told us that she wouldn't be able to babysit that day, so I made arrangements for the neighbor to look in after Sydney.
What happened next?
That's when Hayden brought Jessie over to the house. I let Hayden know that their babysitter wouldn't be in the house that day, but that our neighbor from across the street would be checking in on the kids. Hayden seemed like a little apprehensive about it, but I guess he had to go to work or wanted to go to work. He left Jessie at our house.
Objection, speculation as to whether or not Hayden Duran seemed apprehensive about the situation.
Your Honor, she's not saying that Hayden Durant actually felt or thought any apprehension. She's saying that he seemed apprehensive. That's just her present sense impression of how Hayden Durant externally appeared.
If that's an important point, can you just set a little foundation for it?
So, Mrs. Park, you were saying that you told Hayden Durant no one would be home.
Yeah, Hayden, he took a couple minutes, kind of to think about it to determine whether or not he was going to leave Jessie, but he eventually went to work, just like I did.
Mrs. Park, can you tell us about the phone call that you received?
Yeah, it was about 9:50. I was getting ready to go to a meeting. I got a phone call on the PA system of the hospital. They told me I needed to come to the front desk. I heard a man on the phone. He told me he was a police officer and that something happened at my house. I knew the kids were there, so I just got in my car and drove. But when I got there, there were police everywhere and an ambulance. So I just ran inside.
What happened next, Mrs. Park?
The first thing I saw was a bunch of people standing around a sheet on the ground. And my daughter's feet were sticking out from under the sheet. And it just felt surreal. Like my worst nightmare was coming true. I didn't know what to feel.
When did the reality sink in for you, Mrs. Park?
A minute later, I was on the ground, crying, screaming for Sydney, wishing my husband was there, thinking how I never got to say goodbye to her.
May I proceed with cross-examination?
Please do.
Ms. Park, I know this is a difficult time for you. If you need a moment at any point during the cross-examination, please let me know.
Thank you.
I'd like to talk to you about your daughter, Sydney.
Sure.
Now, Sydney was a bit of a loner at school, wasn't she?
She didn't really have a lot of friends besides Jessie.
She was a quiet girl.
Yes, ma'am.
Even as she got older, she never really had a best friend or any friends come over, did she?
Not besides Jessie.
You and Lee were even worried about Sydney as she got older, weren't you?
A little.
In fact, you and Lee were both happy that Sydney had Jesse to play with.
Yes, we were so excited.
Ms. Park, I'd like to talk to you about Sydney's passion for video games. Sydney loved playing video games, didn't she?
Yeah, she liked computer games the best.
In fact, you and Sydney and Jesse actually bonded over their video games, didn't they?
Yes.
And you always let Sydney play rated E games, correct?
Yeah, she could play them freely.
But you also let Sydney play with other video games with higher ratings, didn't you?
Sometimes, but either myself, my husband, or our babysitter had to be with her.
Thank you, Ms. Park. I'd like to talk to you about the home office. Now, you had a file cabinet in this home office, didn't you?
Yes, ma'am, it was part of our desk.
And in this file cabinet, there was a folder marked for emergencies only.
Yes.
And in this file cabinet, inside this folder, there was a combination for your safe, correct?
Yes, for our gun safety.
You actually caught Sydney going through that file folder once, didn't you?
In May of 2010, when I took away Jesse's game, she was looking for it in there.
Sydney even told you, I know this is where you keep all of your important information.
Yes, ma'am, we did. It had our home security information, our social security cards, things like that.
And Sydney spent a lot of time in this home office, didn't she?
Yes, ma'am.
Often unsupervised.
Yes, for homework.
And you and Lee actually had to kick her out of the office sometimes.
Yes, to do like our taxes,
And she got upset about that, didn't she?
I guess.
Ms. Park, I'd like to talk to you about the gun that you and your husband owned.
Okay.
You're a certified marksman, correct?
Yes, ma'am.
You've grown up owning guns.
Yes.
Lee's grown up owning guns.
Yes, ma'am.
Despite this, you chose a combination for your safe that was pretty easy to guess. correct?
Objection, Your Honor. Under Rule 403, this is misleading. So they're attempting to say that the combination being the birthdays was unsafe because Sydney would have been able to guess it. But the fact of the matter is that Sydney did not guess the combination, so it's irrelevant and it's just misleading the jury.
May I respond, Your Honor? We're not going to show that this combination was easy to guess or that Sydney was able to guess it. Just that the parks failed to provide proper supervision, and because of this, they chose a combination that would have been easy for Sydney to guess, therefore trying to prove the defense's affirmative defense in today's case.
Your Honor, may I respond? Saying that the combination was stored unsafely is completely relevant to their affirmative defense. However, saying what that combination was, saying that it was a series of birthdays and that it could have been easily guessed isn't relevant because Sydney didn't guess it, so it's simply misleading to the jury, and it's far more prejudicial than it is probative.
May I respond, Your Honor? The parks, what we're trying to prove with this is that the parks could have taken more actions to prevent that day from happening. One of those actions could have been choosing a better combination for their home safe.
I'll allow it.
Now, that combination was pretty easy to guess, wasn't it?
It was our family's birthdays, the month and the day.
And based simply on your knowledge, Sydney was aware of all of your birthdays, wasn't she?
Yes, ma'am.
All right, Ms. Park. You also kept that safe in your unlocked bedroom, didn't you?
Yes.
On the floor of your closet?
Yes.
And anybody had access to your bedroom, didn't they?
I guess if you were in my house.
Now, Ms. Park, I'd like to talk to you about the morning of August 18th. It was on that morning that your usual babysitter called in sick, correct?
Yes, ma'am.
And on that morning, you phoned the neighbor across the street, correct?
Yes.
But just the day before, Sydney had actually asked you about your gun, didn't she?
That's when I found out that she knew about it.
She said to you, where do you keep the gun?
Yes, ma'am. I told her she didn't need to know where, and the guns were for adults.
You saw her walk away,
Yes.
and you heard her say to Jesse Duran, whatever, I'm sure it's in her bedroom.
Yes, ma'am.
Despite this, you didn't move the gun, did you?
No, I did go actually check the gun to make sure that it was still locked up in the safe and unloaded after that.
You didn't move the bullets?
No, ma'am, they were in the garage.
You didn't move the combination?
No.
And the very next day, you left Sydney and Jesse completely unsupervised.
Besides the neighbor, I guess.
No further questions at this time, Your Honor.
Do you want to take a break?
Yes, Your Honor, that the plaintiff raises its case in chief.
Okay, how are we doing on time? Do we have enough time for 5, 7, or 10 minutes?
Well,
Five, yeah.
All losses.
Okay,
we
let's
have
go with
a
5 minute break then. Make sure we're doing okay. Anything. I tried to do what you were doing yesterday, like writing notes up here. And then I feel like, oh man, I got right around here, but I'm just screwing this up. I'll change my mind or something. That was good that you followed through. Oh, so what we did yesterday is we sent the blue sheet right, and then the person that was one of he's the guy that led everybody to that. Okay. So he just goes. Yeah, that's just it because lunch is in the same room where he's in. So for their sake, yesterday I just put up my first and the second that he didn't know so I had him work on this and hadn't done this. They were they're all. Well, let's do the blue sheet first, and then we'll send them off. Please be seated.
Your Honor, may the defense begin its case in chief.
Yes.
May we call Jesse Durant to the stand. Good morning, Jesse. Would you please introduce yourself to the court?
I'm Jessie Durant.
Tell us a little bit about yourself, Jesse.
I'm 15 years old. I live with my dad, Hayden, and I'm about to be a freshman at Victoria High.
Can you tell us a little bit about your relationship with your father?
We've always been really close. It's always just been the two of us. He's always been a really, really protective father. He's always been kind of like a helicopter dad, just always watching over me, seeing what I'm doing.
Objection.
telling me what to do.
Character, Your Honor. Her saying that he's a helicopter dad, that he's always protective, watching over her. They're trying to make a propensity argument to show that Hayden Durant had these character traits and that he was acting in propensity with them on August 18th.
Your Honor, we're not offering it for that. We're just offering it to explain the dynamic relationship between the two that is background to the case.
Your Honor, it's highly inadmissible, and if they're trying to introduce some sort of background, I would ask that they do it some other way.
I stick with what I said, that I don't think it's a preponderance. I think that it's just us trying to ask Jesse about what was happening before August 18th.
I'll sustain that objection and strike the last two sentences from the record.
Okay.
The witness's last two sentences from the record.
Yes, sir. Let's talk about your relationship with Sydney Park. What was it like?
Sydney moved in when we were 5 years old. She's my best friend. We did almost everything together. We went to school together. We were always playing together. We were always playing video games. Always playing games at her house.
What type of games did you play?
We always played these video games, these first-person shooter games, where you get to shoot and see it from the shooter's point of view. One of our favorite games was Killer for Hire, but
And Jesse, I know this will be hard, so please take your time, but could you walk us through the morning of August 18th, 2010?
I remember I woke up really early. It was summer. There wasn't much to do, and I remember the day before, Sydney told me that she found a combination to her parents' safe that had the gun in it, and we were going to play with the gun that day because we had always been playing with the video game. just woke up really early and was really excited to go to her house. That was something to do.
Why were you and Cindy so fascinated with you?
I mean, we were just 11. We were just kids. We didn't even know. I don't know. And I remember my dad always telling me that guns were so dangerous in the video games. But
Objection, hearsay, Your Honor. The fact that Hayden Duran told her that guns were dangerous.
Your Honor, in this, she was just stating what all was happening during that time and anything that had happened. We're not trying to offer it as hearsay or anything. We're not trying to offer it as a statement for the truth of the matter, sir. We're trying to show the effect it had on the listener.
The objection is overruled because it's a party opponent. It's about what Hayden, or Mr. Duran said. Is that right?
Well, Your Honor, Hayden Duran is party opponent for the plaintiff's side, but because the defense is offering this evidence, Hayden Duran is not their party opponent. Their party opponent is Miss Andy Park and the Parks.
Your Honor, we're not offering it. It's an exception due to the fact that we're showing the effect on the listener.
May I respond, Your Honor?
Yes, please.
If they are offering this to show the effect on the listener, there's no need to get those exact statements out. They can just say that they had a conversation and then go on to talk about what she did.
We can proceed without exact statements.
I'm sorry?
We can proceed without exact statements.
Okay, please do then it's sustained.
Thank you, Your Honor.
All right, Jesse. So could you walk us through the morning thing?
so once I woke up, my dad was still getting ready for work. So I had to wait a while, and I was gonna go play Cindy's pavement. I remember my dad walked me over to Cindy's house, and I knew that the babysitter wasn't gonna be able to come that day because I overheard my dad and Cindy's mom talking about that the babysitter couldn't come and we were gonna be left alone for the day. And my dad just making sure that I knew to be really careful and to be responsible, and there was just gonna be me and Cindy.
Objection, Your Honor. Those statements by Hayden Duran once again are hearsay, telling her to be responsible and careful.
Your Honor, I believe she was summarizing, not stating a quote or anything of the such.
Your Honor, it's still an out-of-court statement being offered for the truth.
It's not a statement, it's just her summarizing the conversation.
Sustained.
I ask that her last part of that statement be stricken from the record.
Will be stricken.
Jesse, where was the normal babysitter?
I don't know.
So
Danny didn't show up that day.
when your parents left, what happened?
Cindy immediately ran upstairs to the safe, and I followed her. And we opened the safe together, but Cindy opened it, and I was behind her. It was her house, and we opened the safe, and the gun was inside the safe.
Do you know what type of gun it was?
An AT Baker revolver.
And what was the first thing that happened whenever the safe was opened?
Well, since I knew to be careful with guns, I opened it and made sure there were no bullets in there. And because there were no bullets in there, we decided to play with it. But all I could think about in my head is I just wanted to not let down my dad and not do anything stupid, because he believed in me so much and trusted that I would always be safe.
Objection, speculation as to what Hayden Duran believed and trusted.
Your Honor, this isn't speculation, it's showing what she thought of her father and the thoughts that she had.
Your Honor, they're trying to put words in Hayden Duran's mouth and tell us what he was thinking.
Jesse is not trying to say what Hayden Duran was thinking. She was trying to say what possibly could have been.
I'll allow it.
Jesse, after you opened the safe, what happened?
Well, after I made sure there were no bullets in the gun, we started playing with it. We started posing with it. It was really silly, but I made sure that I didn't point the gun at Sydney didn't put my finger on the trigger. I didn't pull the trigger. We just wanted to pose with it and see what it was like to hold a real gun after playing all those games. And we both were taking turns posing with it and playing with it.
What happened after you were done posing and playing?
Well, we got really bored just posing with it. So I remember we went into the living room, and I went in the living room and turned on the TV, and then Cindy disappeared. I don't know where she went. And then she came back. She set the gun on the table and didn't want to watch TV because there wasn't anything good on TV during the daytime, especially during summer. So we were going to start playing with our PlayStation.
What happened next?
I thought we were going to play this game we invented called Roulette, which is a shooter game, but instead of shooting at the other people in the game, we would take turns shooting at each other's character in the video game. But Sydney said, let's play real life roulette, and looked at the gun, and I knew what she meant.
What was your emotional reaction to this? What were you thinking?
I was really scared because there was no bullets in the gun. I didn't think anything could happen, and I really didn't want Sydney to know how scared I was. I mean, Sydney was such a tomboy. That's why we were such good friends. And she was so cool. I didn't want her to think that I didn't want to play.
Okay, what were the rules of this real life roulette? What were you guys going to do?
Well, Sydney invented the rules and said that we each get one shot. She would go first, and then I would go. So Sydney shot at me first. And even though nothing happened, we both went silent. And I was holding my breath the whole time. And it was just so scary, but at the same time such a rush, because it was our first time ever holding a real gun.
After Sydney took her turn, what happened?
It's my turn. And I pointed at Sydney, and I remember the gun feeling differently than it had before when we were posing with it. And when I went to pull the trigger, I remember it felt so much harder to pull it than it looked like in the movies, and it was in the video games. And I shot the trigger, I pulled the trigger, and Sydney was shot, and she was on the floor, and I didn't know what to do. And I just started crying, and I was in shock, and I put the gun on the floor, and I was so confused because there were no bullets in the gun when I checked. And my best friend was on the ground, and I didn't know why.
What else were you thinking during this time, immediately after the bullet was shot?
All I kept thinking about was I didn't want to upset my dad. I just didn't want to be mad at me because he was just always there for me, always getting mad at me and telling me not to be careful when I was playing games.
Objection, Your Honor. This is that inadmissible character evidence and hearsay that we were getting into earlier.
Your Honor, during this time, her thought process and remembering what her father said, she was under duress from the shooting of the gun inside the room.
May I respond, Your Honor?
Yeah.
So I have two objections to what she just said. She said he was always getting mad at me, and then she said he was always telling me to be careful. Always getting mad at me is character evidence, and it was kept out earlier in their direct. Always telling me to be careful is once again hearsay evidence. In order for that to fit under the exception that he is citing, it means that Hayden Duran would have had to be under an exciting circumstance when Hayden Duran said, always be careful. Her being excited doesn't allow that exception to apply.
Your Honor, during this time, she's just remembering what had happened, and she's not saying that her father specifically said those things, she's generalizing. she's not quoting anything again, nothing of the sort.
So it's not an excited utterance?
No, sir.
So then sustain. And the last sentence, sorry.
Yes, Your Honor.
Now, Jesse, after this happened, who walked into the home?
The neighbor, Terry Chapin, she walked in and saw me standing there sobbing, and she came over and we immediately called 911, and she told me that everything was going to be okay, and that she just held me, and I didn't know why I was sitting on the floor. I don't know what happened. Everything after that just went so fuzzy.
Do you remember anything that you said to Terry?
I told her that I shot Sydney, but that was an accident and we were playing a game. And then she was just on the floor. But I told her that I shot her and that I didn't mean to. It was an accident.
Now, Jesse, when the police officers responded to the 911 call, what happened?
They made me go in the kitchen and they gave me a pen and a piece of paper. And they told me to write down what happened. And they just said that if I wrote down everything that happened and I said that I shot her, that everything was gonna be okay and that it was gonna be okay, and I thought everything would go away. But everything was not okay.
Jesse, on August 18th, 2010, did you intend to kill your friend Sydney?
Of course I didn't.
And Jesse, when you pulled that trigger, did you know that one of the consequences could be that you would hurt Sydney harder?
No. When I checked, the gun wasn't loaded. I had no idea. I'm still so confused. I still don't know what happened.
Thank you, Jesse. That's all you want.
Connor, while you're taking notes, would you mind if we set up the courtroom for a demonstrative to use during my cross-examination? We won't show it to the jury yet. Just put the easel in the well.
Yeah, for the sake of this exercise, and then I'll ask for objections when you try to introduce it.
Your Honor, may I move to where I can see the demonstration?
Yeah, sure, we're going to get to that in just a second. But yeah, I mean, it saves time, really. Okay.
Can I proceed, Your Honor? Jesse, I want to talk about something that you just told us on direct. You just said that when you were at Sydney Park's home, the officers came to you and they told you to write a confession. I'm sorry, I'm going to need a verbal answer for the record.
Yeah, they told me to write down what had happened.
And you just told us that they said that you needed to say that you shot Sydney.
That is what happened.
So that's always been your statement, Jessie?
Yes.
Your Honor, permission to approach Jessie Duran with her affidavit? Handing it back to opposing counsel. Permission Jessie Duran with her deposition. Jessie, this is your deposition.
Yes.
And you knew that you were under oath whenever you gave this deposition?
Yes.
Do you know what it means to be under oath?
Yes.
Your Honor, objection. Opposing counsel didn't show me the part that they would be reading from.
Your Honor, we're actually going to be referring to the entire document, and it's not required that we show him in the part.
Okay, are either of you going to be reading from a particular section? or-
Your Honor, my question is about to be that she at no point during this deposition
Okay,
ever
so-
told anyone about what she was just setting forth.
Okay.
So Jessie, you knew that you had to tell the truth.
Yes.
And nowhere in this deposition did you say anything about a police officer telling you to write down that you had shot Sydney.
They brought me into the kitchen and told me to write down what happened. And what happened? I did shoot her and I didn't mean to, but that's what happened.
Jessie, that's not what you said on direct, is it?
Objection, Your Honor. The witness is obviously under trauma during this time, and the details are still fuzzy.
Your Honor, I'm not exactly sure what opposing counsel is objecting to at this point, but my response would be that the fact that she has given false statements in the past goes directly to her credibility and the extent to which the jury can believe anything that she's saying right now.
I think you made your point with this one.
Now, Jessie, I'm going to go ahead and get that back from you. And I want to talk about another time in which you were maybe not as truthful as you should have been. Now, this is the statement that you gave to the police. Is it not?
Yes.
And in this statement, you said that you made Sydney tell you the combination to the safe.
At the time I did, but that's not what happened.
That's right, you changed your story.
I was scared. I just wanted everything to go away. I thought that saying that I didn't want Sydney to get in trouble. I didn't know what to do. I was in shock.
You also said Sydney didn't want to, but I told her it would be fine.
I had just killed my best friend. I didn't know what else to do. I didn't know what else to say.
That's right, Jessie. I know it might be hard for you to be in court today. I want to cover something really quickly. Jessie, you're about to start your freshman year in high school.
I am.
And I know you're sad right now, but Sydney, your best friend, she's not going to get a chance to.
I know.
And Jessie, you're going to go home tonight to your dad.
Objection, Your Honor. Relevance.
Your Honor, she just spent her entire direct examination talking about how she was a victim of what happened. And Your Honor, in today's case, Sydney Park is the true victim. Your Honor, furthermore, the bar for relevance is extremely low. What we're trying to do here is show that while they're trying to recharacterize what happened, the truth of the matter is that Jessie was the one who was holding the gun, and Jessie is the one who's going to get to continue with her life. And the jury needs to hear that.
Your Honor, I think it's assumed that Jessie's going to continue on with her life, but there's no evidence of anything that is going to happen. There's only things that have already happened. At this point, if it's not relevance, then it's speculation.
Your Honor, if it's speculation, she can answer that she doesn't know. It's cross-examination, so if she doesn't know something that I'm asking her, she's welcome to just say, I don't know. At this point, I would just say that the bar for relevance is very, very low, and that we're going to move on very quickly.
I'll overrule the objection.
Now, Jessie, I was just saying that you're going to go home tonight to your dad. Is that true? Well, you're going to see him again.
I don't know. I don't know.
You do know that Miss Park is never going to see Sydney ever again.
No.
I want to back up a little bit. want to talk about what happened before the events of August 18th. You know that well before August 18th, your father was worried about your behavior.
Objection, Your Honor. Jessie did not know what her father was concerned about or not concerned about.
Her father wrote an email that she is familiar with that I'm actually about to introduce, and in this email, her father says, "I'm worried about Jessie." Jessie knows that her father wrote this email.
So let's sustain the objection and then strike the last question and set the foundation first.
Of course, Your Honor. Permission to approach opposing counsel and the witness in turn with this document. Jessie, I'm handing you a copy of the email. You are familiar with this.
At the time that he wrote it, I had no idea.
But Jessie, you have seen this before.
Recently, yes.
It's true, and you know that Hayden Duran, your father, wrote it because it has his email up there at the top.
Yes, but at the time I had no idea.
I'm not asking you about whether or not you really wrote it. I'm asking you about right now, and the answer to that is that you do know what this is.
Yes, and the situation that it's describing.
Jessie, I'm sorry to interrupt you, and we're going to get into that, but right now you can't talk about what's in it before I'll ask you some more questions about it. Your Honor, we offer Plaintiff Exhibit 3 into evidence at this point.
Do you have any objections?
No, Your Honor.
Jessie, now, I want to go through this really quickly. It says, "I'm a little bit worried about Jessie."
It does.
And that was what your father said.
Yes.
It says, "Jessie's been interested in guns for a while.
Yes.
But ever since we got this new video game system, Jessie only wants to play the games that seem to involve shooting hundreds of people."
Objection, Your Honor. Character evidence. The plaintiff is trying to show this to prove that she had a history of bad behavior, but they're using it to destroy her credibility.
Your Honor, we got into this a little bit earlier. While this is character evidence, it's not a propensity argument. It only goes to show that Hayden Duran had knowledge and that he could have predicted and prevented what happened. These are Hayden Duran's statements, and they're incredibly probative in the fact that they show that Hayden Duran knew what Jessie was doing.
So are these questions are these questions better for this witness or another witness?
Your Honor, Hayden Duran has a right not to testify, and he will not be testifying in today's case. So in order to get these statements in, we have to ask Jessie, his daughter, about them.
Your Honor, if we are asking, why are we asking Jessie about it if she did not write this?
Your Honor, she's familiar with it. She knows that her father wrote it. It's in evidence, and we're just asking her about what she knows her father wrote.
Your Honor, it wasn't in evidence at the time. It wasn't, she didn't know about it at the time that the incident happened or immediately thereafter, so I don't see how it's relevant in today's case.
So the contents can be read into evidence?
They can, yes, Your Honor.
Okay. And then this witness's impression, you're trying to get this witness's impressions of this?
Yes, Your Honor.
I'm going to sustain the objection.
Jessie, in this email, your father references you playing a game called Roulette.
That was a game that Cindy invented.
But you used to play it with Cindy all the time.
That was my favorite video game.
And in this email, your father says that he was worried about it.
It was always just like that.
You used to play this game called Roulette in front of him, didn't you?
Because it was a game. Dad knew it was a game.
Jessie, I'm going to go ahead and take the email back from you. But I do want to talk more about this game called Roulette. While you used to play it in front of Hayden, you would never play it in front of Andy in the park.
Oh, but they seem to be the only parents that didn't let their kids play these kinds of games.
I wasn't asking you about which parents let their kids play these kinds of games. I'm just saying that if you had played roulette in front of Andy in Lee Park, you'd think that they would have been super mad.
Objection, Your Honor. the witness doesn't know what Andy and Lee Park would be thinking.
Your Honor, this isn't going to show that Andy and Lee Park necessarily were actually thinking that. It goes to show that Jesse Duran had an opinion of the Parks that they would have been angry if they had seen their kids playing that sort of game. She modified her behavior in that she waited until August 18th when the Parks were out of the home to play her real-life game of Russian roulette.
And what was your question that you had asked her?
You think that if the Parks had caught you playing roulette in their home, they would have been very mad?
Again, Your Honor, that's the plaintiff asking her what the Parks thought.
Your Honor, if she doesn't know that, she can say she doesn't know what the Parks thought. The truth is that she has been deposed before, and she stated that she knew that the Parks would be super mad if they had been playing that game.
I'll sustain that objection.
Jesse, you would never play that game in front of the Parks.
No, Sydney and I always played with my house.
It's because, Jesse, is it your statement today that you never played video games in Parks' household?
We did all the time.
That's right, you did, but you never played roulette in front of the Parks.
They weren't usually home.
You never played roulette in front of the Parks because you were afraid you would get in trouble if you did.
And I didn't want to get Sydney in trouble.
That's right, because you were afraid that the two of you would get in trouble.
Exactly. The two of us. I didn't want both of us to get in trouble.
Jesse, on August 18th, you waited until the Parks were out of the house, and you played a real-life version of roulette.
Me and Sydney both played, yes.
Now, Jesse, you mentioned that you didn't know that that gun was loaded. I want to make something very clear. That morning before you played roulette with Sydney, you made an internet search for how to load a revolver.
I was curious.
So you knew from that internet search how to load a revolver.
Objection, Your Honor. No evidence about an internet search has been entered into the court. They're talking about the specifics of a document or a search that we know nothing about.
Your Honor, we don't need to enter a document for her to tell us what she did that morning.
I'm fine with it, over.
So you made that internet search for how to load a revolver.
It's out of curiosity, but I don't remember reading much of it. Maybe the title. I don't know.
You
I
also
can't
know-
remember what it said.
I'm sorry to interrupt, Jesse, but you also know that your fingerprints were found on that bullet casing.
I would not here today.
Jesse, on August 18th, you held that gun away from your body
That's how you played the game, yes.
and you pulled the trigger.
Yeah, but I didn't think anything was gonna happen.
When Sydney collapsed and fell on the ground, you didn't call the police.
No, I didn't know what to do. I just froze.
You didn't call 911.
I was just a kid.
You didn't call for a neighbor to come help you.
I couldn't speak. I was crying. I was in shock.
Jesse, you did speak with your father on the phone. Because that's who you called immediately after.
And all I remember saying was, I didn't mean to do it. And he told me to call 911 and drop the phone. And that's when Terry Chapin, the neighbor, walked in. And she called 911 immediately.
Jesse, that phone call with your father lasted for 7 minutes.
I mean, I only remember speaking for maybe 10 seconds. And the phone dropped as soon as Terry walked in.
Jesse, even if you only spoke with your father for 10 seconds, that was 7 minutes when your father was on the other line.
Objection, Your Honor. There's no way for the court to know that Jesse and her father were on the phone for 7 minutes.
Is that, it's stipulated?
Your Honor, this witness knows that whenever she made the call, it lasted for 7 minutes.
That's a fact issue.
Yes, sir, but we still have, yes, Your Honor, but we still have no evidence that that happened. The court doesn't know that, only she has evidence that she hasn't entered into the court.
Your Honor, this witness knows that that phone call lasted for 7 minutes. She's testified to it. If she says that
She
it
said she
did.
did.
All right, Your Honor.
Can you set a foundation that she does?
Of course.
Then I'll sustain the objection.
Jesse, is it your testimony today that that phone call did not last 7 minutes?
I don't know how long the call lasted for. All I know is that's what it says on the call log.
Permission to approach opposing counsel in the witness stand. Exhibit 4. Jesse, this is going to Exhibit 4. This is a screenshot from your phone.
It is.
And it's a call to your father.
Yes.
In your contact listing, your father was named Voldemort.
I really liked Harry Potter. Yeah.
And this call was the call that you made that morning.
Mm-hmm.
The call says it lasted 7 minutes.
I told you I only talked to him for maybe 10 seconds and Terry walked in and I dropped my phone. I don't know why it said 7 minutes. I don't know if it didn't hang up, but all I know is I was not speaking for 7 minutes.
Just even if you weren't speaking for 7 minutes, that was 7 minutes when your father was on the other line not calling the police.
Objection, Your
I
Honor.
don't know.
That question was speculation. She doesn't know what the plaintiff doesn't know what the father was doing during that time.
Your Honor, if he was on the other line, she can testify to that. It's rationally based on her perceptions, and if the answer is different, she can say what the answer is.
Your Honor, the defendant could have used a different phone or something of the sort. There's no definitive proof that he wasn't trying to call 911.
Is this something that she has personal knowledge of?
She can testify that he was on the other line on this phone, that he wasn't using it to call.
Your Honor, she testified that she was on the other line, that he was on the other line for 20 seconds. Regardless of what this call log says, they were not in constant communication for the full 7 minutes. There's no proof of that.
I sustain an objection. She's testified as to what she knows. This may contradict that, but that is what it is.
So Jesse, it is your testimony today that this call log is wrong, and that you were only talking with him for 20 seconds.
Yeah.
That's it. Your Honor, at this time, may I tender or publish to the jury the exhibits that we entered?
Any objections? The evidence that was entered to publishing to the jury?
No, Your Honor.
Okay, that's fine.
Your Honor, may I ask if the witness may be allowed to step down?
Yes.
Shall we call the next witness, Your Honor?
Yes.
Defense calls Terry Chapin to the stand. step to the court?
G'day, my name is Kerry Chapin.
What do you do for a living, Ms. Chapin?
I'm a professional motivational speaker.
What does that mean?
I essentially travel the world spreading my message of living a happy, healthy and colourful life to audiences.
Well, where do you call home, Ms. Chapin?
Well, since I've travelled so much, I've called a lot of places home, but I'm originally from Perth, Western Australia, but most recently I live at 23 Maple Street, Fairview, Midlands.
And how does that, how are you here today?
I'm here today because I woke up on the morning of August 18th, 2010 to a really loud banging noise from outside.
Did you know the neighbors well at that house?
I presume you mean the Parks family?
Right.
Yes. Because of my very mobile lifestyle, I didn't really know my neighbors well. However, I did see their child, Sydney Park, playing outside during the afternoons whenever I had like morning flights.
So what happened when you heard this loud bang?
Well, I woke up, checked my phone, saw that it said 9:45 a.m., rolled out of bed and decided that I should probably go check and see what that loud noise was. Because I grew up in Australia, on the outback, I've had a lot of weird gunshots in my life, and I figured that the sound that I'd heard was quite similar. So I rolled out of bed, got dressed, popped a couple of Advil and headed over.
Excuse me? You popped a couple, what?
I popped a couple of Advil pills. I was worried that I might have a little bit of a headache because I'd had this terrible customs journey the day before because I had a flight from Tokyo, and I needed some cocktails to calm my nerves after the flight. So I was worried that the alcohol might have left me with a little bit of a headache. So I preemptively took a couple of Tylenol, Advil.
So what happened as you went to the Parks house?
Well, I walked over. I was going to knock and ring the doorbell, but if there was an armed intruder inside, I didn't think that would be the wisest decision. So I headed over to a window and peered inside the living room. In the living room, it was all empty except for Sydney Parks' body on the ground, which had blood coming out of the head. And it almost seemed like I was in a movie. So I called 911 and reported what I saw.
Did you notice anything else from the street or from the window?
The living room was empty, but I described what I saw in my 911 call.
What else happened in that 911 call?
I had a conversation with the operator regarding the location of the house, and then the operator asked me if I was intoxicated, which I was rather offended by because I assumed that it was just because of the strangeness of my accent. I turn a lot of heads in the Midlands.
Did you proceed into the park home?
I did. I rounded the corner of the house, up to the front door, tried the front door, and noticed it was unlocked, which I thought was strange. So I headed right into the room.
Your Honor, we have a demonstrative, which is a layout of the living room in which Ms. Chapin entered. Maybe construct the courtroom to demonstrate.
May you what?
Construct the demonstrative.
Oh, yeah, any objections?
No, that's fine.
Ms. Chapin, if you'd be so kind, Your Honor, may the witness approach the demonstrative.
Yes.
So, Ms. Chapin, can you please describe where you entered the house?
I entered the house at the front door, which I believe is this point of map.
For a second, do you want to switch sides so you can see better? She's right here.
Is that for you?
Yes, that's fine, thank you.
So, what did you see immediately upon entering the room?
Well, I entered the room from here and glancing into the living room. I saw Sydney Parks' body right here. Her head was right here on the western edge of the coffee table, and the legs were between the couch and the coffee table.
Did you notice anything else in the room?
There was a gun on this side of the coffee table on the ground.
Thank you, Ms. Chapin. Please sit down. What else did you notice upon entering?
one else in the house, to my knowledge. However, Jesse Duran entered the room shortly after I entered the house.
What was Jesse doing?
Jesse was rather non-responsive. Her face was blank. She looked shocked. And then I asked her if she was hurt, if she was okay.
What did Jesse say?
Jesse told me that she wasn't hurt. And then I tried to comfort her, tried to tell her that everything would be all right. And then her lip began to quiver, and her face went into her hands, and she began to sob. I'd never seen a 10-year-old so emotional. But it was rather hard to watch.
What was it that she told you, Ms. Chapin?
She told me that she was so sorry, that it was all her, and then she stopped talking because sirens pulled up.
Who was arriving at the house?
An ambulance and then later a police officer.
And did you speak to any of these people?
I spoke to Officer Williams, the police officer.
Thank you, Ms. Chapin. Your Honor.
Crossrun?
Yes.
Good morning, Ms. When you walked into the house, you said you saw Jesse Duran after seeing Sid. Is that right?
When I walked into the house, the living room was empty except for Sydney, and then Jesse entered.
Right. And when you saw Jesse, Jesse was actually on the phone, right?
Correct. She was hanging up as she walked in.
Right. So she was talking, and you heard her saying, "On the same page, on the same page."
I believe that was what she was saying.
And then she saw you.
Yes, she saw me.
At which point she hung up the phone.
I believe so.
Now, did she drop the phone or did she put it in her pocket?
I believe she put it in her pocket.
Right. So she hung up the phone. She didn't drop it on the floor. She hung it up and she put it away in her pocket.
She put it into her pocket. It wasn't a flip phone, so I don't know about the hanging up situation, but she removed it from her ear and placed it in her pocket.
Okay, great. Thank you. Now, Ms. Chapin, you said that you woke up because you heard a loud bang.
Correct.
Okay, and you stumbled out of bed.
I rolled out of bed, yeah?
You walked over to the park home.
I did.
You saw Sydney through the window on the floor.
I did.
So you called the 911 operator.
I did. Well, I called 911 and the operator answered.
Right. The operator said you sounded intoxicated.
She asked me, "Are you sure you sound intoxicated?"
Right. Then you entered the house, like you said.
I did, through the unlocked front door.
Right. So you entered the home, at which point you saw Sydney.
I had already seen Sydney, but I again saw Sydney's body.
Right. And then you heard Jesse Duran.
Then I heard voices coming from the dining room area, and then I saw Jesse come in.
Right. Now, before you turned and saw Jesse, you just heard the voices, you said.
I heard a voice in the dining room, and I figured that I was about to see a armed intruder walk in on me.
Right. So, Miss Chapin, at that point, you felt a little nauseous.
I did. I hadn't eaten anything the night before, so I just had a ton of liquid in my stomach, and it wasn't the best feeling.
Right. Specifically, that was liquor.
There were vodka Red Bulls, so it was both liquor and energy drink.
Right. So, you were nauseous.
I was nauseous from the liquid inside of my stomach, yes.
You were also blurry-eyed.
From waking up about 4 minutes before, yes.
Exactly. You'd only had about 3 hours of sleep, is that right?
Correct. Because I had jet lag from my flight from Tokyo.
Right. And you said you had drank more vodka Red Bulls than you could count.
Yes. Beginning at 9 p.m. the night before, however, I finished drinking about 1 a.m. in the morning, went to sleep at 6:30, giving myself 5.5 hours to sober up.
Right. And then 3 hours of sleep
Correct.
before you were startled out of bed.
yes, and I wanted to make sure that everything was all right. If I just ignored the situation, who knows what would have happened.
Okay, now, Officer Williams arrived at the scene later.
Yes, an ambulance pulled up, and a couple of moments later, Officer Williams' police car came up, yes.
And Officer Williams spoke to you.
Officer Williams told me to stay out of the way, stay on the porch while he examined the house,
But,
and later in the day, he interviewed me.
right, so he asked you some questions, and you overheard him say that it would be difficult to prove anything with an intoxicated witness.
I believe I had him talking on the phone to another officer.
Objection, Your Honor. These statements are all hearsay. Officer Williams is not present in court here for cross-examination. These are hearsay.
Your Honor, may I respond? They're not hearsay because they're not being brought forth for the truth of the matter asserted. Officer Williams' statements aren't being brought forth to show that Terry Chapman was in fact intoxicated, just that Officer Williams' present sense impression was that Terry Chapman seemed intoxicated.
Your Honor, the statement, this witness will not be reliable, they are intoxicated, is clearly being used for the truth of the matter asserted to attack witnesses' credibility here today. This is hearsay. It goes directly to the truth of the matter asserted in this statement, Your Honor.
Your Honor, may I respond? The plaintiff isn't contending that Terry Chapman was not intoxicated. Terry Chapman has testified that she was hungover. We agree that she was hungover. Officer Williams' statements are simply going to show what his perspective as a police officer was on her appearance at the time. They're not being brought forth to show that she actually was intoxicated.
Oh, thank you, Your Honor.
So Officer Williams, you heard him say that it would be difficult to rely on you as a witness.
Sorry, are you asking if I heard Officer Williams say?
Yes, that's exactly what I'm
Okay, can you repeat the question? I'm so sorry.
You heard Officer Williams say that you sounded, or that you seemed intoxicated and it would be unreliable to have you as a witness.
He didn't use the word unreliable. He said it will be hard to prove something along those lines. It'll be
Right,
hard
with an
to prove
intoxicated witness.
with a 3-pint drinking witness, not
3-pint
necessarily
drinking.
intoxicated.
Okay, with a 3-pint
Never
drinking
heard that
witness.
word.
Thank you, Ms. Chapman. Now let's talk about what else you can testify as to. Can you testify as to who owned the park gun? Excuse me, who owned the gun that Jesse used?
Well, you just asked me the pot gun, so I'm
But can you
assuming-
testify? Is it your knowledge, your understanding that they owned that gun?
all I know is that it was an AT Baking Company 9mm revolver.
But you don't know who owned it.
I don't know.
Okay, can you testify as to how it was stored?
I can't.
Okay, can you testify as to who shot the gun?
I can't. I don't think really anyone can because they weren't there.
Right. Can you testify as to how the gun was fired?
I can't.
Can you testify as to how Jesse Duran came to have the gun?
No, and I'm not trying to.
Right. And can you testify about Jesse Duran's past behavior?
I can't.
Can you testify about any conversations that Hayden Duran ever had with Andy Park?
No.
Okay. Thank you, Your Honor. Pass the witness.
The redirect.
No, Your Honor.
Your Honor, may I use this time to set up the courtroom for the use of demonstrative?
Sure.
Your Honor, at this time, the defense calls Dr. DeRosa to the stand. Good morning, Dr. DeRosa. Can you please introduce yourself to the court?
Of course.
Good morning. My name is Dr. Ash DeRosa. What do you do for a living, Dr. DeRosa?
Well, I'm a tenured professor at Midland State University. My research focuses on public violence incidents, the prevention of violence, and health safety purposes.
How did you get started in that?
I did an undergraduate and a master's degree in public policy, and then a doctorate degree in health policy and management. I teach courses in the related topics.
Do you have any advanced training?
Yes, I have specific training in statistical analysis and research methods specifically relating to gun violence.
Are you published on the topic of gun violence?
I am. I've published around 30 articles in peer-reviewed scientific journals related to gun violence.
Dr. DeRosa, I'd like to talk to you about why you're here today. How are you familiar with the defendant, Hayden Duran?
Mr. Duran hired me to consult in this case regarding the safety of the gun that the Parks owned, which resulted in the death of Sydney Park on August 18th, 2010.
Did you come to any conclusions in today's case?
Yes, I was provided with enough evidence and facts and data to come to a confident conclusion in today's case.
Did you use reliable principles and methods when coming to those conclusions?
Of course, like I said, my research actually focuses on proper methodology. When it comes to gun violence and research, I followed those standard research methods.
And what are those conclusions based on?
My conclusions were based off of a few things. First, I looked at the affidavits that I was provided with. Those were of the plaintiff, Andy Park, the defendant, Hayden Duran, and also Danny Brooks, the babysitter that usually watched Jesse Duran and Sydney Park, the two children discussed here today. I also reviewed on outside research, though, other scientific peer-reviewed journals that are commonly used in my field.
Thank you, Dr. DeRosa. So what was your conclusion in today's case?
Objection, Your Honor. Under 702, this is an improper expert opinion. If allowed to take this witness on voir dire, I can show how she used nothing other than comparison to apply her methods that she was talking about earlier. And this is something that the jury should be able to do on its own. It would not be helpful to the trier of fact as required by 702.
Are you asking that the witness not be allowed to testify as an expert? Or
No,
certified?
we believe that the witness should be allowed to testify to her standards that were used, but we don't believe that she should be allowed to be a summary witness or allowed to backdoor and hearsay about the parks or the condition that the parks kept their gun, because these comparisons between the standards that were used can be made, and to the testimony that we heard earlier today, can already be made by the trier of fact, the jury. So it wouldn't be more helpful as necessary or as specified by the under the ruling of 702 to the jury.
May I respond, Your Honor? I don't think a voir dire would be necessary in today's case. We've already established that Dr. DeRosa is an expert in her field. She's reviewed several different affidavits in today's case, including the affidavit of Andy Park, the owner of the gun. So therefore, she would be able to come to a conclusion based on whether or not she thought that Andy Park stored the weapon properly within her home. That's all she will be testifying to today, and that's an important fact in today's case.
Response, Your Honor?
I'm going to overrule it.
Dr. DeRosa, what was your conclusion in today's case?
I was able to come to the conclusion that the parks did not mitigate the risk that is apparent in every home that owns a gun. They didn't take the necessary precautions and steps that are generally known by the public to take when they have a gun in a home, especially if a child is present.
Dr. DeRosa, what is this inherent risk in owning a gun?
Well, depending on a huge range of issues at hand, the fact that a homeowner owns a gun within their home increases the chance of homicide from 40 to 170%. It's a very large risk to take to have a gun in a home, especially when there's children. The highest percentage of people that suffer these homicides are usually children between the ages of 10 and 14.
Dr. DeRosa, what did the parks do to try to mitigate the risk of owning a gun?
They did do a couple proper steps. I've actually brought along a chart outlining what the parks did correctly and where they failed to correctly store their gun.
And did you prepare this chart yourself before today's trial?
Yes, I did, in my outside research before coming to court today.
Your Honor, permission for the witness to step down to make use of a demonstrative aid.
Do you have any objections to this demonstrative?
Not at this time, Your Honor. I only ask that I be allowed to view the demonstrative.
Permission for the witness to step down.
Sure.
Dr. DeRosa, what is this?
This is a chart that I prepared outlining the general procedures that a homeowner who owns a gun should follow.
I'm the co-director of the Gun Responsibility Board here in Midlands, and these are standard guidelines that we suggest all homeowners follow.
So what is the first standard that you would suggest a gun owner would follow?
First and foremost, a gun should always be stored in a safe. The parks did this, and they did this very well, because they bought a Gigi safe, which is one of the best brands available. It was a smart decision that they purchased that safe and kept their gun in that safe.
Dr. DeRosa, what is the second recommendation that you suggest for proper gun safety?
I suggest that a safe is always stored securely, and by that I mean in a locked room or locked closet if it's going to be within the home. The parks didn't do this. The gun was stored in an unlocked closet in their bedroom where Jesse Duran and City Park had pretty much easy and constant access to.
Based just on the affidavits that you reviewed, did the parks secure the bedroom in any way?
No, based off the affidavits I read, the bedroom was left unlocked, as was the closet where the safe was kept.
What was the third recommendation that you proposed for gun safety?
That bullets are stored securely. Bullets should either be kept in a locked location away from the home or in a separate locked location in the home. Never in the actual safe, and obviously never in the gun itself. Now there was contradictory evidence when I was reviewing the affidavits. One said that the guns were just stored on a shelf in the garage, not in any kind of location. Another said that they were stored next to the gun in the safe. Again, not a wise decision. In either of those circumstances, the bullets were not stored securely.
Dr. DeRosa, what is the third recommendation that you proposed for gun safety? The fourth.
My fourth recommendation is that there be a difficult combination. Obviously, a safe should have a combination. The Gigi safe they had did have a numerical combination. The problem was it was easily guessed and easily found by City Park. It was simply a series of 3 numbers that were the park's birthdays. It wasn't a difficult combination.
And Dr. DeRosa, what was the final conclusion that you came to regarding the combination?
My final conclusion is what was regarding whether or not the combination itself was stored securely. Obviously, in a perfect world, we'd be able to remember every single password, pin code, and combination we had to remember to survive in everyday life. I'll admit I can't remember one of my passwords. Sometimes I have to write them down. But if you do need to write down a combination, it should be stored securely. It wasn't in this case. It was stored in an unlocked file drawer in a room that was left unlocked where Cindy and Jesse Duran frequently played. The combination was not secured securely.
Thank you, Dr. DeRosa. You may proceed. Dr. DeRosa, what was your ultimate conclusion in today's case?
My ultimate conclusion was that the parks did not take the necessary steps and precautions necessary in order to keep the gun that they owned in their own home safe.
Thank you, Dr. DeRosa. No further questions at this time.
Actually, can we go?
Great.
Cross down?
Just.
Hello, Mr. Osa. I want to start with some of the conclusions you were telling us about earlier today on direct.
Okay.
Now, first you said that the safe was not secured or stored securely. But you would agree that gun owners have the right to, or individuals have the right to own a gun.
Yes, of course, that's why I'm on the board of responsible gun ownership. I believe it's a right that we have, and we can choose to have a gun in our home. It should just be stored securely.
And when you store that gun, you want to still leave it accessible in case of emergency or in case you need to use the weapon.
I understand that's often the reason why people do own a gun, and it wasn't the case for the parks. But you have to also think about the risk it is to your own children and family members. The fact of the matter is, if you have a gun, you are more likely to harm someone from your own family than you are an outside intruder. That's why I still suggest a gun should be stored securely.
But you also believe that even if they own a gun, it is not, actually, in this specific case actually, you believe that the parks did not, they stored it in a reasonable location.
The choice to store the gun in the bedroom was not unreasonable. But, in best case scenario, it would have been in a locked room. It wasn't completely unreasonable, just not where I would have stored the gun.
So just to clarify, Mr. Rosa, where they stored the safe, in your professional opinion, was a reasonable location?
It was not unreasonable, but it wasn't the safest option. It should have been in a safe, locked location.
Thank you, Mr. Rosa. I now want to move to the next point that you articulated, that the bullets were not stored securely. Now, you were familiar with the Parks affidavit,
Yes, along with Mr. Duran's and Danny Brooks, the babysitter.
and you understand that the Parks articulated that they kept the bullets in a separate room from the weapon.
They kept the bullets on a shelf in the garage.
And that meets your requirement of storing the bullets in a separate location from the gun.
Yes, but it wasn't in a locked location, nor was it in a hard-to-access location. It was on a low shelf in their unlocked garage.
Regardless though, Mr. Rosa, they did keep them separate.
Yes, and I commend them for that, but like I said, the bullets were not locked away. They were easily accessible to children.
And they did keep the gun unloaded while it was stored in the safe.
Yes, the gun was unloaded.
I want to move to your last conclusion here, that the combination wasn't stored securely. They kept the combination in a file drawer
Yes, they did.
with multiple other files.
Yes, and the combination was marked for emergencies only.
Yes, it was in one of these files marked for emergencies only.
And the only piece of paper in that file that Jesse and Sydney Park both had easy access to.
But regardless, this piece of paper amongst all these files wasn't labeled.
Excuse me?
This combination in the drawer with multiple other files wasn't labeled.
No, the file was labeled. It was labeled for emergencies only.
I'm sorry, maybe my question was unclear. The combination itself was not labeled.
No, it said for emergencies only, and then there was a piece of paper that had a 6-digit combination, the Park's birthdays.
Sounds great. Thank you, Ms. Rosa. I want to move on now to why you are testifying here today. Now, you believe with your testimony that you're able to send a message.
Excuse me?
That you'll be able to send a broader message with today's case.
I believe my general research into gun violence prevention does send a message. I think particularly in this case, it sends a message that homeowners really need to secure their guns. In this instance, it resulted in a tragic accident and the death of, Mrs. Parks' own child.
And you believe if Mrs. Parks was found liable, this would help send that message.
I mean, I think that just this case existing and the fact that this tragic accident occurred sends the broader message that gun owners need to secure their guns, especially if there are children present in the home.
And certainly we can agree if the Parks are found liable, this will help send that message.
I think the fact of the matter that this case is existing and Sydney has already passed away sends that message.
Not only are you testifying here to send a message, though, you were here hired by Hayden Duran.
I was hired by the defense, yes.
And not only did they pay you, but they pay you double your regular hourly rate.
My rate depends on the complexity of this case. This case was very complex. It required around 70 hours of outside work before coming to testify here today. So I charged higher than my normal rate.
And for every hour you were paid $500.
Yes, that's correct.
Now, I want to move to basic understanding of guns for some of us who don't have nearly as much knowledge.
Okay?
Now, when it comes to guns, it is fairly simple to tell whether or not a weapon is loaded.
Depending on the type of weaponry.
With the weapon involved in today's case, the 9mm revolver, it is fairly easy to tell whether or not it is loaded.
Yes, the revolver is pretty easy to tell if you're able to open the revolver and see whether or not bullets are stored. It's pretty simple.
All you have to do is look at the cylinder and you'd see whether or not one of the cartridges was full.
Yes, that's correct.
Now, you said that it depended on your ability to take out the cylinder. I want to talk about how difficult it would be to load a gun. A simple internet search would actually show how to do this.
Unfortunately, you can find anything on the internet today. Yes, you could Google how to load a gun and probably Google how to load any type of gun. You can find that information online, for sure, definitely.
And not only could you Google this information, but there are only 3 movable parts on a gun.
Excuse me?
On a 9mm revolver, there are only 3 movable parts.
Yes, that's correct.
And one of these movable parts is the cylinder.
Yes.
So simply by looking at the gun or messing with it for a little bit, you can figure out how to load a weapon.
Yes, though I think if someone has no prior knowledge of guns, they'd be pretty complicated to figure out. Like I said, you could follow instructions online, like you can for anything these days, but fact of the matter is, guns can be frightening and confusing for people that have never handled them before. From my research in today's case, both Sydney Park and Jesse Duran had never actually handled a gun before.
I'm sorry, my question wasn't pertaining to whether or not these children would be capable, it's whether or not it is possible to look at a gun and figure out how it operates.
Certainly possible, it'd just be complicated for someone who had never actually handled a gun before.
No further questions.
Your Honor, at this time I ask that Dr. Ashtarosa be allowed to step down.
Sure.
And at this point, the defense rests its case in chief and asks for a brief 10-minute recess before closing statements.
You guys?
That would be wonderful.